Hello, everyone. My name is Dev Desai. I'm a partner here at Watson, Farley and Williams, specializing in dispute resolution in the real estate sector. And I'm delighted to welcome you to the summer episode of On-Site Construction. This is the 9th webinar in our series, and one that we have coincided with London International Disputes Week. Today, we have a veritable banquet of insights and expertise awaiting you. But before we tuck in, there are a few housekeeping points. All your microphones and video devices have been and will remain disabled to avoid any unplanned noise interference disrupting our proceedings. Our webinar will last no longer than 1 hour. And yes, it's being recorded so that our speakers' words will be immortalized for posterity and available on our YouTube channel next week. We warmly invite your questions, which I'll be putting to our esteemed speakers at the end of today's session. So please submit your questions using the Q&A function on your screen. If time conspires against us and we're unable to address your query during the webinar, rest assured we'll follow up with you personally. So now let's kick off with our first speaker, Barry Hembling, a construction partner at WFW and board member of the Technology Construction Solicitors Association. Barry will tell you about the new responsibilities of clients, architects, and contractors during the design and build phase under the recent Building Safety Act. Over to you, Barry.
Thanks very much, Dev, and a warm welcome to all our friends and colleagues joining us today, particularly those during London International Disputes Week. So there are new roles and responsibilities for clients, contractors, designers on construction projects. They've been in force since the 6th of April, and in this session, we'll explore a little more about what those roles mean in practice and what can be done to navigate the new regime. So we start by a bit of a background. So the new roles and responsibilities have been introduced under the Building Safety Act. So that's the legislation that's intended to create stronger regulation to make the built environment as safe as possible. So many parts of the Building Safety Act only apply to higher risk buildings. So by way of summary, these are those taller buildings with a residential element that are regarded as being most in need of tighter regulation to ensure the safety of those that live and work in them. In general, it means buildings of at least 7 stories and contain at least 2 residential units. However, there are certain carve-outs from the high-risk building regime, and the following types of buildings aren't regarded as high-risk buildings. So, for example, if you're constructing a hospital, care home, secure residential accommodation, hotel, military barracks, and the height of your building is over 7 stories and contains more than 2 residential units, you don't need to comply with the additional requirements of the higher risk building regime. That means there will be separate building regulations. You'll need to liaise with the building safety regulator and lodge certain information with the regulator. However, there's an important part of the Building Safety Act that applies both to higher risk buildings and non-higher risk buildings. And that's the new duty holder regime that I'll be speaking a little more about in this presentation. Whether the duty holder regime applies or not depends on whether the old building regulations apply or the new building regulations apply. That can be quite a complicated exercise to work out because there are various transitional provisions. We can advise you on that, and questions we would want to understand is whether an initial notice was filed before October last year, whether works have started or completed before April this year, whether the proposed approved inspector has applied to be registered, and what the process is regarding that registration. So if we have answers to those questions, we'll be able to let you know whether the old or new building regime applies. The talk that I'm about to give assumes that the new building regime applies, namely that the initial notice hasn't been filed before October last year and that works haven't substantially completed by April this year. So what effectively is this new building regime? So under the Building Safety Act, Section 34, there is a new duty holder requirement that has been introduced by amending the Building Act 1984, from which the building regulations flow. And the principle behind that amendment is that duty holders should be held accountable for building safety during the design and construction phase. So duty holders are defined very broadly. They're intended to be those commissioning, performing, controlling, or managing construction work. And the duty holders must ensure that suitable arrangements are in place for the work that is carried out to ensure that it secures health and safety. And the principle with the duty holder regime is that there's an overarching obligation for individuals carrying out building or design work to have the necessary skills, knowledge, experience, and behaviours in place to ensure that work is carried out safely. And where the work is carried out by an organisation rather than an individual, the necessary organisational capabilities must be in place. These requirements do not apply in the case of an individual in training. In that scenario, it's necessary to ensure that the right training and supervision is in place to allow the individual to carry out the work safely. And there are certain parts of the regime which can also be delegated in the case of domestic projects. So projects where a client is carrying out works for their own home at their own benefit. So I'm going to look in the next part of the presentation to what these duty holder requirements mean to certain parties performing functions on a construction and design project. And I'll start with the functions of the clients. So a client is defined broadly. It's given a definition as anyone for whom the project is carried out. And their duties on a client include making the appointment of a principal contractor and a principal designer where applicable, where those roles need to be appointed, ensuring the competence of persons working on a project, making certain notifications to the relevant authorities, and ensuring that a person who carries out work on a high-risk building, so namely the 7 stories, the 2 residential units, but not falling in one of those 5 exclusions that we looked at earlier. When high-risk building work is carried out, those involved in the project need to be aware that that's a high-risk building project and that additional building regime rules apply in relation to that work. So many client requirements may be delegated, particularly on domestic projects where you're carrying out a project for your own home. But in general, these are roles that cannot be delegated. And in the next slide, I identify the key requirement of the new duty holder regime, which is around client compliance statements upon completion. So the principle here is that at the end of a project, duty holders must confirm to the registered building control approver that they've fulfilled their duties and, to the best of their knowledge, the works comply with the building regulations. A building regulations final certificate will not be issued by the registered building control approver without receipt of these declarations. So these compliance statements are now a significant departure from the old regime. So formerly it was the case that confirmations could be provided by the person carrying out the building work. Now that may or may not have been the client or the employer. And in addition, the emphasis under the old regime was for the improved inspector to sign off building regulations compliance. The new regime is much more prescriptive as to the role that the client is expected to perform on a project and the paperwork that a client is required to sign. And this idea reflects a new model of risk ownership for building work with clear responsibilities for client, designer, contractor, and owner, all of whom must now be involved to ensure the delivery and maintenance of safe buildings. The next key role is the principal designer. That's defined as the person appointed under the building regulations to perform the principal designer function. Again, where the principal designer is an individual, they must have the necessary skills, knowledge, experience, or behaviors. Otherwise, the necessary organizational capabilities must be in place. The rules for the principal designer relate to the performance of design work. That is defined broadly as the design of any building work. And again, before making any appointment as principal designer, an organization must check that the relevant individual who's intended to carry out that role is able to satisfy the relevant requirements. There are broad duties on the principal designer. Time doesn't permit me to go through them all here, but the emphasis is very much on planning, coordination, and taking reasonable steps to ensure that the design is in compliance with relevant requirements. In addition to the role as principal designer, any other designers on a project also have responsibilities under the Building Safety Act. The designer is defined broadly as any person other than the client, contractor, or other person referred to in the building regulations who carries out design work, arranges for design work, or instructs design work. So the designer must not start design work unless satisfied that the client is aware of its client duties. So there's an obligation on the client to be aware and for the designer to be satisfied that the client is aware of the client's duties. And the designer must also take reasonable steps to ensure that the design is such that if the work was carried out in accordance with that design, it would meet relevant requirements. The next role is the principal contractor. Again, that's defined very broadly. It's the person appointed under the building regulations to perform that role. And like the role with the principal designer, the individual must have the necessary skills, knowledge, experience, and behaviors to perform the task, where an organization has been allocated the role of principal contractor. The organization must have the necessary organizational capabilities to perform that function. Relevant individuals within the organization carrying out the principal contractor role must be properly supervised, and there must be the organizational structures in place to ensure that the work is carried out safely. Roles of the principal contractor include the planning, management, and monitoring of the building work, coordination, taking reasonable steps to ensure compliance, liaising with the other team members. There are also broad obligations on contractors. So that could be contractors other than the principal contractor, subcontractors, nominated contractors under a building contract. So that's anyone who in the course of their business carries out management, manages or controls building work. And again, any contractor is prohibited from starting work unless they're satisfied the client is aware of their duties. There are obligations to ensure work is carried out in accordance with relevant requirements, providing workers with appropriate supervision, toolbox talks, information, and ensuring that reasonable steps are taken to ensure compliance with relevant requirements. Having now looked at the various roles, I just wanted to summarize here and take a look at some of the key points between the principal designer role and principal contractor role. We haven't received any guidance very much on this, but you'll note on the left-hand side, the obligation on the principal designer is very much to take reasonable steps to ensure compliance. So that's the sort of obligation that would be covered by professional indemnity insurance because it's not a fitness for purpose outcome. But you'll note on the right that there's a slightly different obligation on the contractor. So it's not an obligation to use reasonable endeavors or follow a reasonable standard to ensure compliance. The contractor is required to ensure that the building work is in compliance with relevant requirements. So it'll be interesting to see in due course what the view of the insurance industry is regarding these provisions, the extent to which the obligations may impact on professional indemnity insurance, because there are obligations even on the designer to ensure compliance, particularly around the coordination of the design. And that perhaps is a departure around the use of reasonable skill and care that we often see in construction contracts. So we've got more of a obligation to guarantee an outcome, which perhaps is more of an evolution and placing more emphasis on those who are carrying out these roles. So in order to carry out these new duty holder functions, you need to demonstrate compliance. And historically, the building regulations did not impose requirements for the competence of those performing building work. Although there were requirements in CDM regulations, they related to the safety of the project generally, rather than the safety and quality of buildings. So we now have new competence requirements for anyone who performs building work. And the principal designer, the principal contractor, they need to have those appropriate skills, knowledge, experience, and behaviors to perform those duty holder functions. So that means anyone who's involved in managing work must also have the appropriate skills, knowledge, experience, and behaviors. And the organizations involved in that work must have the necessary organizational capabilities. And it's also expected over time that the built environment industry will develop sector-specific competence frameworks that will be used as a benchmark for showing compliance. The new duty holder requirements are backed up with 3 key criminal sanctions. So it's really important that anyone complying with the duty holder requirements follows the new rules. So there's always been the ability for criminal law sanctions for breach of the building regulations. But the first step that the BSA does is to increase the fine for breach of the building regulations, and also expanding the criminal offence of contravening building regulations so that it covers any requirements under the building regulations. So, for example, this could include where certain planning permission has been granted and that those requirements that have been imposed are then ignored and not implemented. So that could also potentially lead to a breach of Section 39. There's also the introduction of mandatory building regulation occurrence reporting. So there's a positive obligation now on parties performing these new duty holder requirements to report breaches to the relevant regulator. There are 2 defenses. One is where the person prosecuted was not aware that the occurrence gave rise to the reporting requirements. And the second is where there are multiple parties who could report, and to avoid duplicate occurrences, it can be a defense that a party reasonably believed, for example, that the principal contractor was making the report where they were carrying out the principal designer role. Secondly, there's a new criminal sanction about liability of corporate officers. So where a body, a corporate body, a company commits a criminal offence under the Building Safety Act, any director, manager, secretary, or other similar officer of that body is deemed to have committed that offence. And when there's sufficient evidence, the company can be prosecuted in addition to the relevant individual. And guidance says that this is not regarded as prosecuting the same person twice. I'll leave you to reach your own conclusions in that regard. The principle is that where both matters result in a conviction, it's for the sentencing court to take account of the relevant sentence that ought to be given to the body corporate and to the relevant individual. Finally, there's a new criminal offence under Section 101 of a breach of a relevant requirement without reasonable excuse that gives rise to risk of death or serious injury. So what does all this mean in practice? So first of all, for the client, really important for the client to take advice. Does the new building control regime apply or not? So that involves going through those questions that I looked for earlier. Was the initial notice filed before October? Has work started before April? They need to appoint a principal designer and a principal contractor under the Building Safety Act. If those appointments are not made, the client carries out those roles itself. Don't assume if you've appointed a principal contractor and principal designer under CDM regulations that you're covered. That's something quite different. We looked at the start how that was more in relation to the safety of a construction project rather than the safety of a building. These are similarly named roles, but they perform a different function. It's also really important for the client to ensure that anyone that it's intending to appoint is able to demonstrate their competence to perform that role. That means they need to ask for relevant information, and decisions about appointments need to be made on competence, not on price. In terms of the principal designer, really important to take advice again as to whether the new building control regime applies, so that the principal designer is aware as to whether or not it needs to comply with these new functions and whether it may be appointed as principal designer. If the new regime applies, they need to be able to demonstrate competence. The organization needs to be able to show that the relevant structures are in place. It's important the records are maintained and that the mandatory reporting requirements are also adhered to. Similar position for the principal contractor and for contractors generally. That's all that time allows me for today. I'm now going to hand over to Ryland, a construction lawyer in our disputes team, who's going to speak about the new JCT Design and Build contract.
Thank you very much, Barry, and welcome everyone. Thank you for joining. I'm delighted to be here today to provide some insight into what the JCT have been up to when updating their design and build contract, and also look forward to the other forms of contract that they'll be updating in due course. So I think it's important to start with the context of these updates. It's been 8 years since the JCT updated their forms of contract. And it's important to remember that around 4 out of 5 construction contracts in the UK are let under a JCT form. That's a large majority of all construction projects being impacted by these forms of contract. Now, in those 8 years, it's important to remember that going back to 2016, we were in a position where interest rates were at 0.5%, inflation was at 0.3%, and this was all pre the Building Safety Act that Barry has just helpfully outlined. So the landscape has changed dramatically. The question is, has the JCT managed to keep up with the times? Well, to give you an overview in the time allowed, I can tell you that they've gone some way towards reflecting the changes in the market, but perhaps they've not gone far enough. First of all, what they've done is they've updated some of the language, which I think has been helpful. It's gender neutral, it's clearer in many cases, and that brings it into line in many ways with other forms of contract, including the NEC contract. And there are other features that are similar to that form. So we've got a new family, as they like to call it, of design and build contracts that were first released. I believe the minor works has been released since then, and I'm sure the other forms will follow in short order. Well, we've got a design and build contract 24, we've got a new guide, the agreement, the conditions, and of course, we've got a tracked changed version. So they tried to streamline the form, but as I say, I'm not sure how far they should have gone. I think they perhaps should have gone further, but they've certainly addressed some of the key issues that we would have expected. They've also included a JCT target cost contract, which is interesting. It borrows from the ideas of the NEC contract, where you essentially have a pain gain share, depending on whether a contractor overspends or underspends on the target price. So that's really bringing it into line with the engineering contracts that are available in the market. And then probably the most major update of all is to bring the contract in line with the Building Safety Act. And what they've done is they've added a new Part 2A, which deals with building regulations. They've also brought it in line with the Construction Act provisions to address final payment provision issues that the courts have been grappling with over these years since the last update. And there's some new insolvency grounds reflecting the Corporate Insolvency Act 2020. So they've also, in respect of payment, tried to take into account the construction playbook, which is guidance for the construction industry around fair payment provisions in contracts, and deals with collaborative working, sustainable development, environmental considerations, and broad green issues in construction. So looking in a bit more detail, first of all, at the changes, one of the most significant changes is on the back of a case where Watson, Farley and Williams were involved successfully in the Supreme Court in triple point technology. And in short, what the courts decided there was that where there is termination of a construction contract, the liquidated damages entitlement stops. And in principle, general damages can follow, or there's an entitlement to general damages after that point. So the JCT have introduced new clause 229.5 to deal with this particular issue. Second up, we've got the contractor's design liability. And what the JCT have done is standardize really the provision in relation to use of reasonable care and skill in respect of design. And that's now within the main conditions. It's worth noting that under English law, where a contractor is designing and building, there is potential for a fit for purpose duty to be implied. And therefore, if this provision is removed in amendments to contracts, that would be the default position. So watch out for amendments around that provision. A very welcome and perhaps a little bit late to the party, the JCT have been in acknowledging electronic communications and signatures of execution of contracts. So we've now got new contract particulars 173 and clause 1.7, which was in the previous forms, recognizing electronic communications and email addresses for the service of notices. The fourth point that I wanted to make in terms of key changes is with regard to relevant events, and I'll come on to relevant matters in a moment. But essentially, under building contracts, relevant events relate to events or issues that can give rise to an extension of time for the works. And what the JCT have done is that they have included provisions for asbestos, contaminated material, and or unexploded ordnance on site in compliance with employers' instructions relating to these issues. So a contractor, if the works are delayed as a result of those issues, would be entitled to an extension of time to the completion date as a result. In addition, they've got an epidemic clause now, finally. It seems like it's a little too late. Obviously, COVID has taken its toll over the past few years, and it's only now really featuring in the central provisions. And then finally, any change in law, publication of guidance on the exercising of statutory power by the UK government is also expressly included, which affects the execution of the work. So there's a tweak there in terms of the wording, probably a slightly broader entitlement for the contractor. And they followed suit on those three relevant events to essentially entitle a contractor to loss and expense, which was not necessarily the position prior to these updates. Under the 2016 form, which was of course pre-pandemic, arguments were essentially settled in favour of the idea that COVID and epidemics could be a force majeure event and therefore give you an entitlement to extra time but no money. And here the default provision is now that you get time and money subject to proving those claims. The next update, which I think is significant in relation to collaborative working, is that we've got a cooperative and collaborative manner being expressly provided for, and good faith and the spirit of trust and respect. For those of you who are familiar with the NEC engineering forms of contract, there's already a provision in those for the spirit of mutual trust and cooperation, and that's had some attention in the courts. The question is, what does it mean? Some very interesting case law around this, but time doesn't permit a full rundown. But there is a very interesting fairly recent Scottish case where that provision was tested, and the courts said that essentially it only takes you so far, and what you can't do is act inconsistently between two provisions. So in that case, the attempt was to omit work and give it to another party. The court decided that was a breach, and they said that it was a breach because it was inconsistent with clause 10.2, which provided for a spirit of mutual trust and cooperation. So I suspect the English courts will follow suit broadly with the concept that this cooperative, collaborative and spirit of trust and respect extends probably to being honest and fair in your dealings with the counterparty under the contract. The next and perhaps the most significant updates are, of course, in relation to building safety and the Building Safety Act. The new duty holder obligations that Barry has explained have been introduced, are expressly recognised under the contract in the core provisions, and each party undertakes to comply with their duties under the building regulations. The new roles of the principal designer, principal contractor are identified in Article 7, and they're referred back to in subsequent clauses. It doesn't specifically deal with higher risk buildings, which I think is something that may leave it open to some criticism. And you can't see, obviously, any reference to the golden thread of information, mandatory occurrence reporting, which essentially will require further amendments to be made to the contract where relevant. The specific provisions available on the JCT website, but those would not be appropriate for all building types. We're in a position to advise and draft those provisions, of course. So the other amends in relation to the Building Safety Act have essentially been brought together under what were the CDM related provisions in the design and build contract, and they now refer to both CDM regs and building safety obligations. In relation to payment and the Construction Act, as I said initially, there are some new provisions which refine really the termination payments, in other words, payments post-termination, and some tidying up of the due dates in that regard, and the final date for payment as well. In terms of dispute resolution, there has been a shift to encourage ADR, and there is now an optional provision. There was an optional provision, which is now a core provision, to notify and try and negotiate and meet as soon as practicable for good faith negotiations to resolve the matter. So there's certainly a push towards avoiding formal dispute resolution, but it's important to remember that you have the statutory right under the Construction Act to dispute and go to adjudication at any time. And the parties may now add their own name for an adjudicator, nominating body, or an arbitration appointer. So in summary, I think that the JCT have gone some way towards updating their provisions in line with the industry, but I don't think they've gone far enough. And I'm afraid that's all I've got time for. So I'm going to hand over to Dr. Laura Lintop, who is of counsel in our disputes team.
Hi, everyone. Thank you very much, Ryland. It's a pleasure to be here. So it's time to talk about party walls. And this is a personal passion of mine. I'm actually a construction and international arbitration specialist, but this is something that I'm very, very focused on as well. So party walls are like salt, and we may not perceive them on a day-to-day basis, but they affect most of us. To be able to help members of the public, there is a need for a new contextual approach to party walls that goes well beyond the Party Walls Act. Party wall dispute resolution needs to be recognized as a valid consolidated area where different areas of law and fact are brought together with the aim of more cost and time-effective party wall dispute prevention, management and resolution strategies, as the notice procedure under the Party Walls Act is not the only dispute resolution option available. Party wall disputes can be highly personal in nature. It is common for these to grow acrimonious with emotions running high, standing in the way of pragmatic solutions where if a dispute ends up in court, its value can be often lower than legal costs. And therefore ADR, alternative dispute resolution as opposed to litigation, is desirable way forward as it can preserve or repair relationships between landowners and save money and time. Most importantly, the Party Walls Act does not apply where the building owner fails to trigger the notice-based dispute management mechanism created by the Act. Although this is a statutory breach, it does not result in criminal liability. And I will refer you to the well-known Court of Appeal decision in Power and Shah last year. The problem is that the parties then lose protections that the Act provides. If the adjoining owner then suffers any damage or loss as a result of the building owner's works, so this is then only actionable in court in private nuisance, and the building owner may also be liable for trespass. There needs to be a new approach to party wall disputes. Such disputes should no longer be viewed as peripheral issues linked to property, construction, or commercial disputes and projects. So I have an upcoming book on this, but before I go in there, typical images of party walls in accordance with the government booklet. And I am going to shortly talk about what a party wall is, but my upcoming book is based on my PhD thesis and formulates a separate area of party walls and related disputes of its own merit, providing a contextual analysis that brings different areas of law and fact together and aims to help resolve party wall disputes in a practical and time and cost-effective way. And this includes the notice procedure under the Act, but most importantly, it advocates for other alternative dispute resolution avenues. So first, it dissects the definition of what a party wall is, and it is not only the definition under the Party Walls Act that's relevant. It is an important foundation, but there are other definitions to be aware of, including the from the Department for Communities and Local Government's explanatory booklet. Now, I'm not going to read out all of these definitions, but I'd like you to have them so that you see that they vary from each other and they relate to different things. They relate to ownership and they relate to the works, and all of them together create an important map. Then, secondly, my book analyzes the Party Walls Act, its history, what lies behind it and its purpose, the areas it covers, and the rights and obligations of parties connected to party walls. Thirdly, the book analyzes ways in which to manage and resolve party wall disputes. There are a number of issues with litigation. The adjoining owner needs to bring a claim in court, first of all. The court can decide at its own discretion whether it considers it appropriate to award damages, injunctive relief, or specific performance, depending on the facts of each case. And while the courts will generally sympathize with the adjoining owner where it is a victim of damage caused by works performed by the building owner who failed to serve the appropriate notice under the Act, there is no guarantee that the relevant court will actually grant the relief the adjoining owner is claiming for. Judges are people, and one cannot 100% predict what they will do. If the adjoining owner cannot proceed with such a claim, for example, due to time or financial constraints, personal circumstances, the building owner is unlikely to suffer consequences of its breach of statutory duty. And importantly, there is the issue of excessive time and cost I mentioned earlier. But there are other cheaper and faster ADR options so that parties do not end up in court or can suspend court proceedings by agreement for the duration of ADR and negotiate a settlement instead. So the notice procedure under the Act is obviously something I cover as well. And I have created brand new diagrams that take you step by step what to do in a situation where there is a dispute between the adjoining owner and the building owner. So I hope that these will be helpful for everyone, lawyers, general public, academics, and help with some disputes, or if not even prevent them. Now, to ADR, the Party Rules Act is a statute, and as such, it cannot be opted out unless if it were to be permitted by the Act itself, which sometimes certain legislation allows, but that's not the case in the Party Rules Act. However, according to recent case law, it is possible that the parties, by agreement, ensure that the dispute resolution procedure in Section 10 of the Party Rules Act is not engaged. The main point is that on the clear wording of the Party Rules Act, there must be a dispute before Section 10 is engaged. And if the parties reach an agreement, the effect of which is that there is no dispute, then Section 10 cannot apply. Now, shorthand for this is, as it's been mentioned in a recent case, I will quote that you can opt out of the Act. That's strictly speaking not correct. But what it actually means that if you settle by way, for example, mediation, and there is no dispute, there is nothing to engage under the Act. There are three crucial cases I would like to mention, and that is Dillard, I'm sure you've heard of that, Mohammed and Larry and Antino, and Taka and Mohammed, and all of these three cases support the points I just mentioned. So ADR options include, and I will not mention all of ADR options, obviously, but those most relevant to party rule disputes. So negotiations between the parties in dispute that can be with or without lawyers, expert determination, and then my favorite, mediation, which is a speedy, relatively cheap dispute resolution method, which can help preserve relationships between the parties. And also the parties can choose for everything in the mediation to be confidential. Now, courts encourage ADR, and where the parties refuse to participate without a reasonable foundation, this can result in court-imposed cost sanctions on either or both of the parties. Fourthly, my book talks about other pieces of legislation. So it's very important not to view the Party Rules Act in isolation. There are other acts that I've just listed on the slide that directly either interact or even engage with the interact with the Party Rules Act or clash with it. I will not go into detail on that now, but what I'm trying to say is that there's a lot of literature focusing on the Party Rules Act, but it's important to see it in the context of this legislation. Then I also talk about proprietary rights in land affecting party rules and related disputes, with a particular focus on easements. The Party Rule Act is very clear on neither condoning nor authorizing interferences with easements. Awareness of these issues means that parties can decide before a dispute arises what works to perform on a party rule and in what way, in order not to interfere with any connected easements, with the aim of avoiding a party rule dispute altogether. And in the chapter of easements, I discuss interplay between party rules and the right of way, right of support, drainage rights, and whether there are any ancillary rights or obligations of repair in relation to party rules. Next, I also touch on torts, with a focus on common law nuisance relevant to party rules. Tortious issues such as noise, vibration, or interference with rights to light can be intrinsically linked to party rule matters that impact such tortious rights. And in any case, the common law, i.e. here the law of tort, continues to exist. But in certain circumstances defined by the Party Rules Act, it is overridden by the provisions of the said Act. And then finally, practical aspects, because law is very important, the legal aspects are very important, but when it comes to party rules, it's structural matters and practical factual matters related to construction matters that are relevant as well. So I devoted a chapter to that. And finally, I'm going to mention party wall legislation reform. So reforms are necessary to ensure cost savings for public and private entities. I mean, the Party Walls Act has been around for nearly a quarter of a century, and some suggestions that I've listed here include introducing or updating certain definitions in the Party Walls Act, for example, formulating a definition of a party wall surveyor, as regulation of party wall surveyors ideally qualified professionals who are subject to a professional body disciplinary procedures would lead to an improvement of the quality of party wall awards. Next suggestion is making it clear what rights, if any, pass on to successors in title. So clarity on that would be helpful. Thirdly, providing for the Secretary of State or Lord Chancellor to approve a procedural code for party wall surveyors to follow when making awards would seem sensible. Next, imposing more severe consequences for the for the building owner who fails to issue the relevant notice under the Party Walls Act, while also giving a limited opportunity to the building owner to fix absence of such notice to enable the Act to apply and for the adjoining owner to avoid the necessity of going to court. Why I'm trying to balance this point is that on one hand, you don't want situations where a building owner goes rogue, and in any case, building owner who thinks that not engaging the Act is in their advantage is not necessarily the case, because then if the adjoining owner goes to court, that's not good for anyone. But then on the other hand, you do have building owners who genuinely just miss the deadline or are not aware, who genuinely want to fix it. So it's good to give them the opportunity to do that. That's my view anyway. Final 2 points. So currently, where the relevant notice has not been served under the Party Walls Act and works have started and or have been completed without the service of such a notice, the Party Walls Act does not apply retrospectively, and therefore any related dispute would have to be decided in court unless parties agree to an ADR venue. So a solution to this issue would be to amend the Party Walls Act so that it applies retrospectively, or to ensure that any superseding legislation has a retrospective effect. And then finally, the dispute resolution mechanism under the Act relates only to disputes arising under the Act and does not encompass all possible disputes related to party walls, such as those related to easements, tort, boundary disputes, and thus leaving questions within disputes unanswered. In connection with reforming or replacing the Party Walls Act, as its provisions are currently limited and not able to cover many of the complexities linked to party wall disputes, a checklist could be put in place that members of the public should have regard to when involved in a party wall dispute. And this checklist could be presented either in the same manner as the current government explanatory booklet, alternatively as an annex to the Technology and Construction Code Guide, or as a separate practice direction. So in conclusion, my aim is to bring all those areas of law and fact together that are most relevant to party wall disputes, to provide a more comprehensive understanding of party wall disputes, and for this to be accessible to the public, and to promote ADR to resolve such disputes in a practical and effective way. So watch out in the next few weeks, book is coming out. This is me. And then I will hand over to Deepa Deb, our fabulous head of International Real Estate Investment Department.
Perfect. Thanks very much, Laura. Really appreciate that. I'm just going to make sure I've put my camera on for everybody. Hopefully that's now working. Thank you very much. So you've heard about the Building Safety Act, changes to the JCT, and of course about the changes that we need for the party wall. So now for something completely different. I wanted to share with you what we're seeing both nationally as well as internationally in relation to global real estate trends. As transactional practitioners, we have the benefit of seeing deals from all angles, whether that's on the investment side, the financing side, operations, development, as well as occupiers, which puts us in a good position to comment on the state of the market. And based on what we at Watson Farley Williams are seeing, we would describe 2024 as being a year of two halves thus far. As we all know, I'm sure 2023 was all about surviving, keeping the lights on in the hope things could only get better in the real estate sector. Cap rate increases and the scarcity of debt finance meant we all had a pretty tough end to 23. At the beginning of this year, the hope was that buyers and sellers of properties were starting to accept a higher for longer interest rate environment, and they were therefore finding the middle ground on pricing, and that had been so elusive over the past 2 years. And certainly in the UK, we saw deals beginning to be brokered in the early part of the year based on pricing correction. With the alignment on pricing and seemingly more clarity on global monetary policy came the belief that real estate can recover from one of the worst investment downturns in years. This was very much the sentiment that was pervading at MIPIM 2024. I remember folks speaking about the green shoots of recovery. In practice, however, post-MIPIM, interest rates, of course, went the wrong way, therefore impacting trading sentiment. At Watson Farley, we observed a number of deals falling over due to last-minute price trading, or simply deals taking an inordinate period to execute. Owners now seem to be coming to terms with painful property value losses. Buyers and sellers can't seem to agree on pricing, partly because of the shortage of transactions limiting price clarity. Given all of this, it might surprise you that actually we continue to see a trend that has surprised even us, which is that investor appetite for real estate has not waned. Investors remain eager to acquire new assets, likely probably reflecting recent and expected price declines, making this a more favorable entry point for acquisitions after what's been almost a decade of relentless appreciation. A number of industry experts are now saying that cap rates will rise further next year, which may lead to falling values again. To summarize sentiment, we at Watson Farley would say that we find ourselves in a bit of a holding pattern currently, while there's a realignment of expectations between buyers and sellers. Sellers have not yet fully adjusted their expectations to current market conditions. Industry participants are also blaming debt markets, interest rates, the cost of capital. These are all high concerns in the minds of folk, as well as capital availability. Whilst debt is viewed as slightly more available than last year, both debt and equity underwriting are becoming much more rigorous. But despite these capital market challenges, many in the industry remain hopeful, if not a little bit less optimistic than is typical for our industry. But we do all recognise there is no shortage of capital to be invested in real estate, and the appetite remains. So what can we expect and where? Which cities, which asset classes? Now, at this point, I'm slightly concerned that this is being recorded because no doubt I'm going to have egg on my face by the end of the year, but here goes anyway. Post-pandemic, I think we all agree the purpose of office buildings is being challenged, much like people started to question the need for retail space almost a decade ago when e-commerce emerged as a more convenient and economical alternative to in-store shopping. Malls have, of course, not disappeared, though there are fewer of them. Office space seems to us to be going through a comparable reconsideration. We're seeing a flight to quality. Rents per square foot for grade A, sustainable buildings and gateway cities remains at an all-time high. A significant share of the existing inventory of office is functionally obsolete and will need to be repurposed or demolished to make way for higher uses at great expense to their owners. Take, for example, what we're seeing at Canary Wharf. This is, of course, selfishly good news for all of us in the construction sector, as refurbs and repositioning are, of course, right up our street. There remains activity in the market for high-quality logistics. The pandemic accelerated e-commerce and online shopping and the need for more logistics. I was surprised to learn that for every sale that happens online, we require 3 times more warehouse space than in-store sales. Accordingly, we expect continued strong demand for high-quality modern logistics facilities as companies continue to optimize their supply chains. We are starting to see more of a focus on onshoring or nearshoring to secure supply chains. In addition, the living sectors remain strong, by which, of course, I'm referring to multifamily, student, and even senior living, excepting that residential for sale remains challenged due to land values, difficulties with planning purposes. What we're seeing is that owners who have in-house operating expertise can acquire these sorts of assets at attractive values and pursue value-add plans to boost growth. In Europe, we believe that the widening gap between the cost to own and the cost to rent will increase the number of renters and as interest rates remain high. and supply is scarce. When we think about housing, we see attractive opportunities not only in the traditional sense, but also in alternative types such as co-living, single-family units, and micro-living. Again, office to residential conversion gives rise to more opportunities for refurbishment projects. Good news for all of us in the construction industry. The other sort of surprising trend is what we've seen happening in the hospitality industry post-COVID. As the hospitality sector continues to recover, we expect operating complexity, higher debt service, and capital-intensive nature of hotels to create motivated sellers. We see opportunities to target undermanaged, undercapitalized assets and platforms to give us exposure to this market. We see increasing demands for hotels. The other trend that we're seeing is that the pandemic obviously made clear to all of our governments that countries need to be able to perform research and development and biomanufacturing onshore to support continued innovation and access to critical healthcare inputs. Separately, private companies with complex global supply chains have realized that in periods of stress, they need to have those critical functions housed domestically. We're therefore seeing an increased focus on the life sciences sector. Everyone is, of course, talking about the increased use of AI. Whilst the real estate sector may be slower than others on the uptake of AI, what can't be denied is that AI is here to stay and it needs to be housed. So we're seeing the emergence of a strong demand for data center space. ESG remains an important theme, with the focus shifting more to the S from the E, but of course the E remains completely at the top of most investors' priority groups. And we're seeing a real emergence of new energy sectors. Certainly at Watson Farley, we're involved in a number of these infrastructure projects. In terms of sought after cities, we've seen appetite for London, Paris, Madrid, and the Netherlands remain strong. Germany less so on account of pricing. So just to conclude, and very conscious of time, the fundamentals for high quality real estate remain strong. Demand is continuing to outpace supply in many markets. The rise in replacement costs and supply chain issues are shrinking future pipelines. This is leading to a positive upward pressure on rents in countries and regions around the world. A lot of our clients are saying that the objective is to invest in strong assets and portfolios that can not only survive, but outperform in all business cycles. So we consider there is going to be a window of opportunity to acquire attractive investments on a value basis, and investors are going to need to be agile and ready to deploy. As to when we're going to see this window of activity open up, well, optimists are suggesting Q4, realists are suggesting Q1 next year, but what we all agree on is that it's a question of when and not if. Thanks very much for listening.
Thank you, Deepa, for your erudite tour of international real estate. I'm also grateful to the insights from Counsel Dr. Laura Lintott and partners Ryland, Ash, and Barry Hembling. Whilst you were all talking, we've had a number of questions coming through from our audience. We'll not have time to go through all of them, I think, but let me pick a couple to put to you. I think this question is best placed to Ryland, I think. Ryland, are you expecting the extensions of time arising from events such as epidemics to be carried through to other contracts? And I think a connected question, which is, are you aware if insurance is available for any residue risks, such as interest and overheads?
Yeah, thank you, Dev. Yes, I think in short, I will see more of those extension of time provisions being carried across, because there is an appetite to have consistency between those provisions. What you don't want is to have too much risk on one party in the middle of a procurement chain. So I think you'll see time and money for epidemics, for example, becoming more standardized. In terms of the second part of the question, at the risk of not predicting what the insurance industry may or may not offer, I am aware that I think there were some insurers offering business contingency policies, which would take account of indirect losses in certain cases, but I don't think it's an industry-wide offering. I think it's quite a narrow and specific offering, but there certainly was insurance available. So it's a question of looking at the market.
Thank you, Ryland. The next question, I think, is probably for Barry. It says, you mentioned that designers and contractors may have to demonstrate competence. If they're asked to do so, how should they go about doing that?
Yeah, really good question, and very much a live issue on everyone's lips at the moment. There was a paper released by the Health and Safety Executive 18 months or so ago. I think it's the PAS 8671 and 8672. Have a look at that. It doesn't contain a lot of detail. It very much duplicates the key provisions of the Building Safety Act. But the key measures from that paper suggest that competence can be demonstrated in three ways. First of all, formal training, CPD. Secondly, by experience of building your portfolio of other jobs where you may have come across examples of identifying and managing building safety risks, and also knowledge, showing that you can plan, monitor, control building safety risks. And it's also expected that professional bodies will start introducing maybe qualifications courses, CPD points, in order to assist in demonstrating competence. So keep an eye out for that too.
Thank you, Barry. That's very helpful. I think in terms of Q&A, that's all we're going to have time for today. I can see that others have asked questions, so rest assured we'll be in touch with you directly to answer all of those. And thank you everyone for joining us today. We really hope you found it informative and food for thought. A feedback form will be circulated to you shortly, and it really helps us hone these seminars for you if we can have your comments. So please do take a few minutes to do so. If you've dialed in today into the webinar, please email events@wufw.com to say that you attended. And the recording of the webinar will be available on our YouTube channel next week. So if you'd like your colleagues to be enlightened by this on-site construction episode, they can watch that. Otherwise, may I wish you a pleasant day. Goodbye.
Bye.